Testing, testing, testing. Alright. Today we're going through 2015 Florida statutes under Title 36, Business Organization, Chapter 605, Florida Revised Limited Liability Company Act. Rather than go through all the articles, we're going to start with we're going to read the whole chapter. Definition is used in the chapter. The term acquired entity means entity that has all one or more of the classes, series, or interests acquired in interest exchange. Acquiring an entity means the entity that acquires all of one or more classes, a series of interests of the acquired entity in its interest exchange. Articles of conversion, means of article to conversions required for statute 605-1045, or the term includes the articles of conservation as amended and restated. Articles of domestication means the articles of domestication required under statute 605.1055. The term includes the article of domestication as amended and restated. 5. Articles of interest exchange means the articles or interest exchange required of statute 605-1035. The terms include articles of interest exchange as amended and restated. 6. Articles of merger means that the articles of merger required under statute 605-1025. The term includes the article of merger as amended and restated. Articles of organization means of article or organization required under statute 605.0201. The terms include the articles of organization amended and restated. By the way, we're going over definitions. 8. Authorized representative means in the case of formality of a limited liability company, a person by a prospective management liability company to form a company executing files in its articles of organization with the department. In the case of existing liability company with respect to executing, filling out the record of the department, taking in any other action required under this chapter. 1. The manager or manager managed limited liability company who is authorized to do so, a member of the management limited liability company who is authorized to do so, or an agent or officer limited liability company who is granted the authority to do so, such as a manager or such a member pursuant to the operating arrangement of liability limited liability company pursuant to statute 605.0709. C. In the case of foreign limited liability company, any other with respect to executing filing record with the department taking any action required authorized underneath this chapter, a person is authorized to file the record of taking action on the behalf of the foreign limited liability company or other entity. 9. A business day means Monday through Friday, excluding a day the National Banking Association is not open for normal business transactions. 10. Contribution. Except for the phrase of right, contribution means the property of the benefit described in statute 605-0402 is provided a person liability company to become a member of which is provided with a person's capacity as a member. 11. Conversion means a transaction unauthorized under state statute 605-104 through 605-1046. The converted entity means the converting entity continues existing after the conversion. 13. Converting entity means a domestic entity that approves the plan of the conversion pursuant to state statute 605-1043. The foreign entity that approves the conversion of the pursuant to the organic law is in jurisdiction of formation. 14. Day means of a calendar. 15. Debitor in bankruptcy means a person who is in subject of any order for a relief under Title 11 of the United States Code with successor statute general application. B. A comparable order under the federal, state, and foreign law governing insolvents. 16. Department means of the Department of State. 17. Distribution means the transferring the money of any other property from the limited liability company to a person on the account other of a trust interest in the person capacity as a member. A. The terms include a redemption or the other purchase of limited liability company of a transferable interest. 2. A transfer to the member to returning the member's relinquishment of any right to participate as a member of the management to conduct company activities, affairs, relinquish the right to access the records or other information concerning the company's activity um, and affairs. The term does not include constituting reasonable compensation for the present and past services. Payments may be made in ordinary course of business under the bona fide retirement plan or bona fide benefits program. 18. Distributional interest means the right under the unincorporated entity, organic law, or an organic rules to receive distribution from the entity. 19. Domestic with respect to any entity means the entity whose jurisdiction of the formation is the state. 20. Domesticated limited liability company means domesticating entity and continues in existing for the domestication. Domesticating entity means the non-United States entity approves the domestication pursuant to the law of the jurisdiction and formation. 22. A business entity, a business corporation, a non-profit corporation, a general partnership, including a liability limited partnership, a limited partnership, including liability limited partnership, a limited liability company, real estate investment trust, any other domestic or foreign entity that is organized under the organic law. B. The entity does not include an individual with a predominantly denoted purpose of charitable trust, an association relationship with not a partnership solely by reason of statute 620, 8202, and a similar provision for law of another jurisdiction. 4. A descendant estates, and 5. A government of the government until subdivision and an agency instrumental. 24. Filling entity means of entity whose formation requires the filing of the public organic record. 25. Foreign with respect to an entity means the entity with the jurisdiction of the formation of the jurisdiction of other than this state. Foreign limited liability company means the unincorporated entity that was informed in a jurisdiction other than this state is denominated by the law of limited liability company. 27. Governance of interest means the right under the organic or laws or organic rules of the unincorporated entity other than a governor, agent, or assignee or the proxy to receive, demand access to information concerning the entity or books and records. Vote of the consent of the election of the governors of the entity to receive notice of vote on a consent to issue involving internal affairs of the entity. 28. Governor means a director of business corporation, a director of the trustee, and the non-profit corporation, a general partnership, a general partner of the general partnership, a general partnership of a limited partnership. E. A manager of the managed limited liability company, a member of the managed limited liability company, and director of the trustee, real estate investment trust, any other person whose authority for the powers of the entity are excused and under whose direction activities are fair for the entity and managed with the pursuant of the organic law and organic rules of the entity. 29. Interest means a share of the business corporation, a membership of in the non-profit corporation, a partnership in interest of the general partnership, a partnership in the interest of the limited partnership. E. The membership in interest of the limited liability company, a share of the beneficial interest of the real estate investment trust. G. A member interest of the limited cooperative association, a beneficial interest in statutory trust, business trust, or common law business trust, or a governance interest in the distributional interest in their entity. Interest exchange means a transaction authorized under statute 605-1031 and through 605-1036. Interest holder means a shareholder of the business corporation, a member of the nonprofit corporation, a general partner of a general partnership, a general partner of a limited partnership, a limited partner of a limited partnership, a member of the limited liability company, a shareholder of the beneficial owner of the real estate investment trust, a beneficiary or beneficial owner of the statutory business trust or common law business trust, and another direct holder of an interest. 32. Interest holder liability means that the personal liability for a liability of an entity which is imposed on the person solely by the reason and statutes of the person and the interest holder by the organic rules of the entity which make one of the more specified holders categories of the interest holder and the capacity interest holders for all specified limited and entity the obligation of investment holders for the under the organic rules of the entity to contribute in the entity 33 jurisdiction if used to refer to the political entity means the United States, the state, or the foreign country or political subdivision of the foreign country. For jurisdiction of formulation means the respect to the entity. A jurisdiction whose organic law entity is formed, incorporated, created, otherwise and comes in being. However, these purposes of the entity under the law of the jurisdiction, different jurisdictions under this entity originally was formed, incorporated, created, otherwise came into being. The jurisdiction under this entity that exists is treated with the jurisdiction formation. B. In the case of limited liability partnership, foreign limited liability partnership jurisdiction in which the partnership statement of the qualification equivalent document is filed. 35. Legal representative means the respective natural person, personal representative, executor, guardian or conservator of any of the person who is empowered to applicable law with the authority to act on the behalf of the natural person with the respective person of the natural person, a person who is empowered by applicable law with the authority to act on the behalf of the person. 36. Limited liability company or company except that the phrase of the form limited liability company means to entity formed existing under this chapter and the entity becomes the subject to the chapter pursuant to 605-1001 to 605-1072. Majority interest means that the members who hold their 50% of the current percentage of the interest of the profits of the limited liability company owned by all of its members. However, they are used in state statutes 60101. 605-1001 to 605-1072. The term means in this case limited liability company with only the class and series of numbers holders are more than 50% of the current percentage interest of the profits company owned by all the members who have the right to approve the merger interest exchange conversion applicable under the organic law organic rules for the company. In this case, limited liability company have more than one class of series members holders in each class of the series more than 50% of the current percentage over the interest of the profits company owned and all members of the class series who have the right to approve the merger interest exchange and conversion as applicable to the organic law of the organic rules of the company unless the company organic rules provide with the approval of the transaction different for the manner. 38. The manner means of the person who is under the operating arrangement of the manager and the managed limited liability company and responsible for the loan in concert with the others and for performing the management function stated in the statute 605-0407, 605-040732. Manager management liability company means the limited liability company that is managed by virtue of this operation of statute 605-04071. Members mean means a person who is a member of limited liability company under statute 605-0401 was a member of the company with the company being subject to this chapter has not discussed the company under 605-0602. Member of this management limited liability company means the limited liability company is not the manager managed limited liability company. Merger means the transaction authorized under statute 605-1021, 605 through 605-1026. Merging entity means the entity of the party of the merger to exist immediately before the merger becomes effective. The non-United States entities means a foreign entity other than entity with jurisdiction formation and that is not of the state's operating or agreement means that the agreement would refer to the operation arrangement which may be oral, implied, or the record. If any of the combination there may be the members of the limited liability company including a sole membership concerning the matters that are described in statute 605-0105. The terms include the operating arrangement amendment with the restated 46. Organic law means the laws of the jurisdiction with the entity is formed. 47. Organic rules mean the public organic record or the private organic rules of the entity. 48. Person with the individual business corporation, nonprofit corporation, partnership, limited partnership liability, limited liability company, limited cooperative association, unincorporated nonprofit association, statutory trust, business trust, common law business business, trust, estates, trusts, and association ventures, public corporations, government and government subdivisions, agencies, instrumental and other legal and commercial entity. 49 plans of the merger and plan inter-exchange plan conversion of a plan of domestication as appropriate with the particular context. 50. The plan of conversion means the plan under 605 and 1042 that includes the plan of the conservation of members of the restated plan of domestication means the plan under 605 104 includes the plan of domestication amended with the restated with the interest exchange means that the plan under the 605 103 2 includes the plan of the interest exchange and the amended restated with the plan of the merger means the plan under 605 1022 includes the plan of the merger as amended with the restated. 54 principal office means the principal executive office of the limited liability company, foreign limited liability company, regardless whether the office is located in the state. 55 private organic rules means the rules, whether or not in core record with the governor, internal affairs of the entity, are binding of all interest holders and are not part of the public organic record if in the terms. Bylaws of the business corporation, laws of the nonprofit corporation, partnership agreement, the general partnership, the partnership agreement with the liability, limited partnership, the operating arrangement, limited liability company. The bylaws and trust interests, similar rules, real estate investment trust, the trust instruments of the statutory trust, similar rules of the business trust, common law business trust, property means all property with the real and personal mix of the tangible, intangible right of the interest therein. 57 protected agreement, the record of evidence, indebtedness, and related agreement, and the effect of January 1st, 2014. An agreement is binding on any entity of January on any entity on January 1st, 2014. The organic rules of the entity is in effect after January 1st, 2014. An arrangement is binding of any of the governor's interest holders of the entity of the January 1st, 2014 public organic rules record means the record of the filing of the government body is required for the entity as amended with the reinstate of the statement of the record with the term includes the following: the articles of corporation of business corporation, the articles of incorporation of non-profit corporation, the certificate of limited purpose partnership and unlimited partnership, the articles of organization and limited liability company, the articles of incorporation of the general cooperative association, limited cooperative association, the certificate of the trust of the statutory trust or a similar record of the business trust, AG, the articles of incorporation of the real estate investment trust. 59 record is used in the nouns and means of the information described in the tangible medium where it is stored in electronic or other medium and is retrievable for the perceivable form. The registered foreign entity means the foreign entity is authorized in the transaction, business, and state pursuant to the record filed with the department. 61 registered foreign limited liability company means the foreign limited liability company that has the certificate of authority to transact as the business in the state of the pursuant to the record with the department. 62 signed means that the president is present intent of the authenticate and adopt a record to execute, adopt the tangible symbol to attach the logically associate the electronic symbol with the sound of the process with the record, and it includes the manual facsimile or confirmed electronic signature. The terms sign and signature have been corresponding to the mean state means of the state of the United States, the District of Columbia, Puerto Rico, the United States Virgin Islands, a territory insular possession subject of the jurisdiction of the United States. 64 surviving entity means the entity of the continuous existence with the created of the merger. 65 transfer includes assignment, the conveyance of the sale, lease, and encumbrance, including mortgage, security, and interest, a gift or transfer of operational law. 66 transferable interest means the right of the initial owned of the person who is person capacity as a member to receive distribution of limited liability company in accordance with the operation agreements with the person remains the member that continues to open and a part of the right of the return applies to the fraction of the interest which whomever owned. Transfer means the person with which all part of the intransferable interest is transferred, whether or not into the transfer is a member of this in term includes a person whose transferable interest under the 605.0603 first and C. Type of entity means a generic form of the entity and recognized as the common law. formed in an organic law, whether or not some of the entities formed under the organic law are subject to the provisions of the law that created different categories from the form of the entity. 69. Writing means the printing of the typewriting, electronic communication, intentional communication that is reduced into a tangible form. This is written for the correspondence to meaning history. 605 103 knowledgeable notice. A person knows of the fact, and then the person has actual knowledge of the fact, is deemed to know the fact under the paragraph of or law under this chapter. The person notices the fact of when the person the reason known the fact from all the facts from known to the person at the time of the question, and deemed the notice of the fact under the paragraph 4b, subject statute 605-02-110. Personal notifies another person of a fact, taking steps person responsibly required to inform the other person the ordinary course of events, regardless of whether the steps actually caused the other person to know the fact. For a person who is not a member is deemed to know the limitation authority to transfer real property as provided in 605-0302 and notice the limited liability companies. 1. Dissolution. 90 days after the article dissolution filed under 605-07-07 become effective. The termination date 90 days after the statement of termination filed under 605-0709 becomes effective. Participation in the merger, interest exchange, conversion, domestication. 90 days after the articles of merger, articles of interest exchange, articles of conversion, articles of domestication. Statute 605-1025, 605-1035, 605-1045, 605-5, respectively, become effective. Declarations and the articles of organization that merge and manage in accordance with statute 605-0201 3A. However, in such declaration has been added and changed the amendment, the reinstatement of the articles of organization. Notice of the addition, changes may not become effective until 90 days after the effective date in such amendment, the reinstatement. Grant authority, the limitation imposed by the authority of the person holding the position having specified status of the company. Grant authority limited imposed on the authority of the specific person. And the grant authority limitation imposed by the authority described in the Articles of Corporation in accordance with the 605-0201. However, if the description has been added to change the amendment of the reinstatement of the Articles of Organization and notice for the additional change that may not be effective until 90 days after the organization effective date, such as amendment, reinstatement to the provision, articles of organization, limited authority, the person where transfer real property held in the name of the limited liability company as noticed that the such limitations of the limitation to a person who is not as a member of the manager of the company unless the limitation appears in the affidavit of the certificate or other instruments that bear the name of the limited liability company as is a record of office of the recording the transfer for the real property. 605-104 governing law. The law of the state governs the internal affairs of the limited liability company. The limited liability company of the member as a manager for the debts, obligation, and other liabilities of the limited liability company. 605-0105, operating arrangement agreement in scope and the function limitations, except for otherwise provided in subsection 3 and 4. The operating arrangements govern for the following: A, the relationships among the members and as members between the members as a limited liability company. B, the rights and duties under this chapter as a person for the capacity of the manager, activities and affairs of the company, the conduct of these activities and affairs, the means and the condition of the amending of the operating arrangement. To the extent of the operation of arrangement for the does not otherwise provide with the matter described in the subsection. The chapter governs the matter and operating arrangement may not do any of the following for their limited liability company capacity under 605-0109 to sue and to be sued is its own name. B, the very law applicable under 605-104, very law requirement, procedure, other provision of the chapter pertaining to the registered agents department, including the provision pertaining to the records authorized required to deliver the department of filing under this chapter. The D, the vary the provisions of 605-0204, limiting the duty of the loyalty or duty of the care under the 605-04-091, expect otherwise provided in the subsection. F. Eliminate designation good faith and the faith dealing under the 6050491 by operating arrangement may be described as standard for the performance obligation measured in the standards that manifest unreasonably. G. Relieve and exonerate the person from liability for the conduct involving bad faith with full intentional misconduct or knowing violation of law. H. The unreasonable restrictive duties rights stated in 60504 and 10, but the operating arrangement may impose the responsible restriction of the availability of the information obtained under the section defining the appropriate remedies, including limited liability damage for the breach of the reasonable restriction use. I. The grounds of dissolution specified in the 6050702. J. The very requirements to wind up the company business activities affairs as specified in 6050709 2A and 12A and 5. Unreasonable restrictions the right of the maintained under 6050801, 6050806. The provisions of 6050804 for the operating arrangement may provide the company may not appoint the special litigation committee. However, the operating agreement may not prevent the court from appealing the special litigation committee. Vary the right of the member to approve of the merger, interest, exchange, and conversion under the statute 605-10231B, 605-10331B, 605-10431B, respectively. They required the contents plan of the merger of 605-1022 and a plan of interest exchange 605-1032, the plan of conversion 605-1042, the plan of domestication under statute 605-1052. Except for otherwise provided in 605-106 and 605-107, 2 restricts the rights under the chapter of the person under the member of the range, provided in indemnification of or a member of the manager under the 605-1048 for any other of the following: conducting involving bad benefits, willful intentional misconduct, knowing violation of law, transaction from the member of the manager derived from the improper personal benefit, the circumstance under the liability provision 605-0406, applicable breach of the duties of obligation to 605-04-091, taking the account of the restrictions and expansion and elimination of such duties obligation provided by the operating arrangement to the extent allowed by the subsection. 4. The subject of the paragraph without limiting other terms that they may include the operating arrangement of the following applies. A. The operating arrangement may specify the method by which the specific act of the transaction would otherwise elevate the duty of loyalty may authorized or ratified by one or more disinterested independent persons after the full disclosure of all material facts. After the prohibition stated in the statute 605-04-051B, the prohibition requires solely that the company totally assess not to be less than the sum of the total liabilities. B. To the extent of the operating arrangement, member management limited liability company expresses relieves member reasonability for the member that would authorize under the chapter imposed the responsibility in one or more of the members of the operating arrangement to be a benefit of the member of the operating arrangement, relieves the responsibility eliminating or limiting duty of the obligation that would be pertinent to the responsibility. C. If not manifestable or unreasonable operating arrangement after and eliminating aspects of the duty of law duty of loyalty under 605-04-091-2, identifying specific types of categories of activities that do not violate the duty of loyalty. Alter the duty of the care may not authorize and willfully, intentionally misconduct knowing the violation of law. 4. After eliminating other fiduciary duty. 5. The court shall decide in the matter of the law whether the terms operating arrangement manifest unreasonably by the paragraph 3.5 and paragraph 4c. The court shall make the determination of the time limit of the challenge term which became operating arrangement, shall consider the circumstances existing at the time, may invalidate the term only if the light of the purpose activities affairs a limited liability company, if readily apparent that the objective of the term is unreasonable to the unreasonable means to achieve the provision objectives. An operating arrangement may provide the specific penalties and specified consequences, including those described if the members transfer the fails to comply with the terms and conditions of operating arrangement or other events specified in operating arrangement occur. 605-0106, operating arrangement effective limited liability company and person from becoming a member of the pre-formation agreement and other materials involving operating arrangement. Limited liability company is bound and may enforce the operating arrangement regardless of whether the company has itself manifested assent to the operating agreement. A person who becomes a member of the limited liability company is deemed to assent into its and bound may enforce the operating arrangement regardless of whether the members execute the operating arrangement. 3 to 2 or more who intended to become the initial members of the limited liability company may make the agreement, providing that upon the formation of the company, the agreement will become an operating agreement. One of the persons indicated because the initial members of the limited liability company may assent to they will become operating arrangement formation of the company. A manager of limited liability company transfers and is bounded to the operating arrangement regardless whether the manager and transferee has agreed to the operating arrangement. 5. The operating arrangement limited liability company has one of the members not unfortunately simple that there is one person who is party to the operating arrangement, except as provided in 605-0403, then an operating arrangement is not subject to statute of fraud. 7. An operating may provide as a right to the person, including a person who is party to the operating arrangement, to extend the provided by the operating arrangement, a written operation agreement, or other records may provide a person that admitted with the member of the limited liability company becoming the transfer of limited liability company interest, having other rights and powers of the member to the extent assigned. 1. If the person represented the authorized person orally or written in their action and payment with the limited liability company executes the operating arrangement and another record extending evidence intending the person to become a member of the transferee, and without executing the operation agreement, the person represents an authorized person orally and writing and other such payments with limited liability company interest and complies with the condition that for the becoming of the member, transferee is provided in the operating arrangement and another record. The is unenforceable by reason or has not been signed, a person will be admitted as a member of the becoming of the transferee's paragraph provided in paragraph 4A by the reason being assigned and represented provided in this chapter. 605-0107. Operating arrangement affect a third party's relationship to the records on behalf of the limited liability company. An operating arrangement may be specified that the amendment requires an approval of the person who is noted as a party of the arrangement upon the satisfaction of the condition of the amendment of the effect of the adoption does not include the required approval and satisfies the specific condition. Application of limited liability company members of the person to the person capacity transfer of the person dissociated as a member of the government operating arrangement, of the amendment of the operating arrangement made after the person becomes a transferee is dissociated as a member, and the effect with regarding the debt obligation or other liability, limited liability company is a member of the person for the person capacity as a transferee, a person dissociated as a member it is not effective to the extent of the amendment imposes the new debt obligation or other liability on the transfer person dissociated as a member. If the record of the delivery of the Department of the filing becomes effective under this chapter that contains the provision would interface with the statute 605-0105-3 4C contained with the operating arrangement provisions effective with the record for the subject subsection if required 3 if required to deliver to the Department of the filing has become effective for the under the chapter but conflicts with the provision of the operating agreement. A. The operating arrangement prevails if the member to dissociated transfer the manager of the record prevails if the person extent for the other person reasonably rely on the record. 605-0108, nature, purpose, and the duration of limited liability company. Limited liability company is any distinction of the members. Limited liability company may have a lawful purpose regardless of whether the company has a for-profit company. Limited liability company has an identified indefinition term duration. 605-0109. 0109. Powers. Limited liability company has the power of the rights and privileges granted by the chapter by any other law operating agreement to do this. All necessary conveying with the carry to the end out its activities and affairs, including the power to do all the following: sue, be sued, doing defend its name, purchase, receive, lease, and otherwise acquire, own, hold, improve, use, and otherwise deal, real personal property, any illegal equity and interest property where they're located, sell, convey, mortgage, grant, and security interest and lease, exchange, otherwise encumbering, disposal of all part of the property, purchases, receive, subscribe, otherwise acquire, and own, hold, vote, you sell mortgages, and grant the security interest, and otherwise dispose and deal in and share the other interest in the obligation of another entity. Many make contracts, guarantees, incur liabilities, borrow money, issue notes, bonds, and other obligations which convertible into the convertible option is purchased for the security of the limited liability company to make the contracts guarantee the suretyship of which is necessary for the convenience of the conduct, promotion, and attainment of the purpose of the activities and affairs of the limited liability company. 6. Lend money to invest, reinvest in the funds received and hold real property, real or personal property as a security for the payment. Conducting the business located official exercise the powers granted for this chapter within this without a state. Select the manager of the appointed the officer, director, employees, agents of the limited liability, and define the duties of the fix of their compensation, lend them money in the credit, and make donations to public welfare, charitable, scientific, or educational purposes, pay pensions, establish pension plans, pension trusts, office sharing plans, bonus plans, option plans, benefiting an incentive plan for any of the all occurrence of the former managers, members of officers, agents, employees. 11. Become a promoter, incorporated shareholder, partner, member, associate manager of the corporation, partnership, joint venture, trust, other entity, make payments, donation, or conduct any other act of inconsistent with the applicable law with further business and limited liability company. 14. Any enter interest rate basis currency hedge or other swap agreements, cap, floor, the put, call option, exchange of the collar agreements, derivative arrangements, and similar agreements. A grant holder exercise power of attorney, including the irrevocable power of attorney. 6050110. Limited liability company property. All property originally contributed with the limited liability company subsequently acquired for the limited liability company by purchase of other methods limited liability company property. Property acquired for the limited liability company funds is limited liability company property. Instrument documentation provided with the acquisition, mortgage, and the disposition of the property limited liability company are valid, binding, and under the liability company if they are executed in accordance with this chapter. Remember, the limited liability company has no interest in any specific limited liability company property. 6050111. Rules of construction supplemental principle of law. It is in the attendance chapter the maximum effect of the minute principle of the freedom of the contract and the enforceable of the operating arrangements, including the purpose of the statute. 6050105. Executing 605-107. To the extent of the law of the equity of the member, the manager, and other persons of the duties, including fiduciary duties and limited liability company, and any other person, member of the manager, or to any other person that is party otherwise bounded by the operating agreement, the duties of the member of the manager and other persons may be restricted, suspended, limited, including determination of applicable duties and obligation of this chapter. The operating arrangement extended in extent allowed in 605-105, unless displaced in particular provision in chapter the principle of law of equity, including the common law principle relating to the fiduciary bonds of the law, loyalty, and care of the supplemental chapter. 605 name. 605-10112 name. The name of the limited liability company must contain the word limited liability company or the abbreviation LLC. The most distinguishable record of the division of the company of the departments from the name of the other entities of the filing with that are on the file of the division, except for the fictitious name registered in the statute 865.09 general partnership registration pursuant to 620-8105, the limited liability partnership pursuant to 629-1001, which organized, registered, and reserved under the law of this state. However, the limited liability company may register under the name of the other distinguishable other records of the division, written consent of the other entity, and the consent filled with the division at the time of the registration, such as name, the differential name of another entity, filing of the duty. Due to any of the following, it is not considered distinguishable. Suffix, definition, indefinite article, word, and symbol, the singular, plural, possessive form of the word, recognizable abbreviation, root of the word, punctuation marks of the symbol. May not contain a language stating and implying with a limited liability company organized with the purpose for the authorized in this chapter the articles of organization. May contain language setting and implying with a limited liability company connected with the state, federal company, government agencies, corporations, and any other type of the charter ordered under the law of the United States. Subject to statute 605-0905. The section applies to the foreign limited liability company transaction business state which has certificate authority to transact business in the state which has applied for the certificate authority. 3, in this case, a limited liability company extended to July 1st, 2007, registered the department requirement for the section of the name of the limited liability company to distinguish the name of the other entity filing and applies limited liability company documentation for the after July 1st, 2007, which would be authorized to have effective in its name. Limited liability company extend for the January 1st, 2014, registered in the department using an abbreviation designation. The name authorized under the previous law may contain the abbreviation designation of the name until it is dissolved and mentions the name of the record of the department. The name of the limited liability company must be filled in the Department of the Public Notice, and the act of the filing of the loan does not create the presumption of ownership beyond the which is created under the law. Okay, registered agent. Each limited liability company, each foreign limited liability company that has a certificate of authority under 6050902 shall designate and continuously maintain in the state a registered office which may be the same as the place of the business in the state. B, a registered agent who must be an individual who resides in the state whose business address is identical to the address of the registered office. Foreign domestic entity authorized to transact with the business in the state whose business address is identically to the address of the registered office. 2, initial registered agency. Each successive registered agent that is appointed shall file with a statement in writing with the department to form the manner prescribed by the department. Accepting the appointment of the registered agent will simultaneously be designated as a registered agent. The statement of acceptance must provide that the registered agent is familiar with, accepts the obligation and the position. 3, the duties of the registered agents are as follows. A, to forward the limited liability company registered foreign limited liability company as an address most recently supplied to the agent of the company in the foreign limited liability as a process note or demanding and pertaining the company of the foreign limited liability company which is served received by the agent. B, if the registered agent is reassigned to provide the notice under the statute 6050115 to company foreign limited liability company to address, then most recently supplied with the agent of the company of the foreign limited liability company. The department shall maintain an accurate record of the registered agent, registered office of proposed, and shall promptly furnish information disclosed thereby upon the request and payment of the required fee. Limited liability company. Each of the foreign limited liability companies certificate authorized in 6050902 may not persecute, maintain, and defend an action in the court until the limited liability complies with the section. Pays the department the penalty of $5 for each day that it failed to comply with or $500, whichever is less, pays the amounts required under this Chapter 6050114, change of the registered agent or registered office. In order to change the registered agent, registered office address, limited liability company forward, limited liability company may deliver the department for the filing of the statement, changing the following: the name of the limited liability company for limited liability company name. The name of its current registered agent, the registered agent to be changed. The name of the registered agent, the street address of the current registered office of the registered agent. If the street address of the registered office is changed, the new street address of the registered office is in the state. If the registered agent changes, written acceptance of the successor registered agent described in the 6050113A must also include an attachment for the statement changing. The statement changes in effect with the department of the authorized in statute 6050207. The change described with the section also made with limited liability company foreign limited liability company annual report application reinstatement with the department of 6050715. The amendment of the reinstatement of the company articles of organization in accordance with 6050202. The amendment of the foreign limited liability company certificate of authority in accordance with 6050907. 6050115, resignation of registered agent. A resignation agent may resign a limited liability company, foreign limited liability company, delivering to the department of the signed statement of the resignation company to the limited liability company of the foreign limited liability company. After delivering a statement of the resignation, the department of the filing registered agent shall mail a copy to the limited liability company for the limited liability company current mailing address. 3, registered agent is terminated upon earlier A, the 31st day of the department of the statement of resignation. B, the statement of the changing under record of designation new registered agent is filled with the department For the when a statement of resignation takes effect, the registered agent ceases to have the responsibility, therefore, attending the agent limited liability company, form limited liability company. The resignation does not affect the contractual rights of the company, form limited liability company, as the agent or the agent has assigned, or the agent that is against the company or form limited liability company. 5. The registered agent may resign from a limited liability company, foreign limited liability company, regardless whether the company or foreign limited liability company has active status. 6050116, to change the new address of the registered agent. If the registered agent changes his or her name of the address, the agent may deliver the department with the filling of the statement of discharge provided the following: the name of the limited liability company, foreign limited liability company represented by the registered agent, B, the name of the agent as currently shown in the record of the department of the company, foreign limited liability company, if the name of the agent has the new name of the place, new name, if the address of the change, and the new address of the registered agent given the new notice required under section 2. The registered shall properly furnish with the statement of the change and may change made statement with the filled with the department represented with the limited liability company, foreign limited liability company. 6050117, service process notice and demand. Limited liability company registered for the limited liability company may be served in the process notice and the demand of the required authorized law of the servicing registered agent. 2. The limited liability company registered for the limited liability company ceases to have registered agent if the registered agent cannot with reasonable diligence to be served. The process notice demand required permitted the law may be instead of be served. On member of the member management limited liability company registered foreign limited liability company, on manager management limited liability company for registered foreign limited liability company. 3. If the process notice of demand cannot be served in limited liability company, registered foreign limited liability company, pursuant to the subsection 2, subsection 1, subsection 2, the process notice demanded may be served the department as an agent of the company. 4. The service of the process notice demanded the department may be made of delivering and leaving the department, duplicating the copy of the process of notice and demand. 5. The service is effectuated with under subsection 3 the day shown in the receipt in the department. 6. The department shall keep the record of each of the process notice demanded and served the pursuant to the section record of the time and the action regarding the service. 7. The section does not affect the right of the served process notice and demand in any other manner provided by law. 6050118, delivery of record. Except for the otherwise provided with the chapter of the permissible means of the delivery record include the delivery by hand, the United States Postal Service, commercial delivery service, electronic transmission. Except for as provided the subsection 3, delivery to the department is effective only when the record is received in the department. 3. If the check of the mail is the department of payment of the annual report of the annual fee required in the statute 607-1093, the check shall be deemed and have been received at the department as a postmark appearing for the envelope packaging transmitting the check if envelope or a package is received in the department and by the department. 6050119, waiver notice. If the pursuant of the chapter, article, or organization operating or arrangement of the limited liability company notice is required of giving the member of the limited liability company to the manager of the limited liability company having the manager or the manager's waiver or writing signed of the persons and entitled to notice whether made before or after the time of notice be given an equivalent to the giving notice. 6050201, formation of a limited liability company, articles, or organization. One or more persons may act as an authorized representative for a limited liability company, signing and delivering articles, organization, the department of the filing. The articles or organization must state the following: the name of the limited liability company, which must comply with statute 6050112, the name of the limited, the street and mailing address of the company principal's office, the name and street address, and the state of the written acceptance of the company's initial registered agent. The articles or organization may contain the statement as a matter than required for the under section subsection 2 may not verify otherwise effect for the provision specified in 6050105. The manner inconsistent with the subsection additional statements may include one or more of the following declaration as state as to whether the limited liability company is managed and purpose for the statute 6050407 and the other relevant provisions of chapter. Hi, Mama.
I need you.
All right.